Hi everybody, my name is Elizabeth and I'm the broker for Star Bay Realty, and today I'm going to talk to you about the as-is residential contract, not to be confused with the standard residential contract, which is also another form you can use, but it is different in a few ways, and we will get into detail about that as we go along. So to begin with, you will go ahead and enter in the name of the seller and the name of the buyer. If the name of the seller is only one person on the county property appraiser website, but they are technically married, and they are subject to homestead regulations, you need to include both the husband and wife's name on here because they both need to sign the contract. Same goes with the buyers. If they're a married couple who will be subject to homestead exemptions or tenants in common, they both need or any type of tenancy like that, they will both have to sign the contract, so include both names on here. Next, you will go ahead and enter the address of the property. And enter the county. And go ahead and enter the tax ID number, which can be found on the property county website. And you can go ahead and find the tax ID or folio number here. I'll go ahead and copy that here. And the legal description can also be found on the property county website. If you scroll down somewhere on there, it will say something about legal description. And then you can just copy and paste that. If it's a really long one, which some of them are, you could just type "see attached" and just attach it on a separate paper. Personal property, go ahead and include any personal property that will convey with the home, such as washer, dryer, refrigerator, etc. This is a good time to talk to your buyer to make sure that they are aware of what will convey with the property and what may not. You can look at the MLS listing to see if the listing agent said any particular items will not be conveying with the property. Next, you will go ahead and put in your purchase amount offer and any deposits that will go with the offer. It can either accompany or be made within a certain number of days. If you leave it blank, 3 days after the effective date. Technically, you're not supposed to keep this information blank in regards to the escrow agent information. If you are asking for the seller to choose a closing company, you can contact the listing agent to find out who the closing company will be, and you can go ahead and enter that information here and just have that closing company hold the escrow. But you don't have to. It could be any escrow company holding the escrow, but sometimes it just may be easier if the closing company, whoever will be doing the closing, go ahead and hold the escrow as well. And if you're making any additional deposits after the effective date, you can notate that here. If there is financing, then you will go ahead and notate that here. You can notate the amount that will be financed as either a percentage or a certain amount. Once you enter that in, the balance to close will automatically be calculated for you. So in this example, the purchase price is $200,000 and you're financing 80%. That would leave you a balance to close of $40,000, but it's also taking into account the $10,000 you're putting in deposits, which is why it calculated out $30,000 in balance to close. Next, you will select the time frame that you're going to allow the seller to decide if they're going to accept your offer. And then you would also select a closing date, assuming they accept your offer by that date. I would go with at least 30 days, if not more, especially if you're financing. that will give you some time to get your financing approved. As you know, with the Consumer Financial Protection Bureau closing disclosure requirements, the buyer is required to receive the lender's closing disclosures at least 3 days prior to the closing date. So if that does not occur, you need to extend the closing date. You don't need to create an addendum because there is this clause which will automatically extend the closing date if something like that occurs. If the property is subject to the lease, you will go ahead and check off here. Otherwise, the property should be free of tenants and all future tenancies. If the property is going to be assigned, you would notate that on here. There are a few options here. The buyer may assign and thereby be released from any liability under this contract. This is sometimes a little cautious. If you're the listing agent, I would be a little wary because it may indicate that the buyer is trying to sell the contract, but maybe not. It could be for another reason. The buyer may assign but not be released from this contract. Sometimes this happens if the buyers are not sure how they want to purchase the contract. Perhaps they're deciding on a corporation, LLC, or some other type of ownership. So maybe they need to consult with their accountant or legal counsel. So this gives them time to decide on that, but still be able to go under this contract. Or you can just select plain old may not assigned and therefore not be released by this contract. Financing. Obviously earlier we put that we're financing, but if for some reason we were not financing, we would go ahead and select we're paying cash, and there will be no financing contingency. If we are doing financing, you will go ahead and select option B and select the type of financing that the buyer is trying to obtain, and go ahead and fill out the terms of the financing that they are trying to obtain. If this portion is left blank, then it will default to 5 days, but you can put earlier. That is the amount of days that the buyer has to apply for financing after the effective date. So make sure your buyer does apply for financing within that time frame, because if the buyer does not apply for financing, they technically would be in breach of the contract and are at risk of losing their deposit. It is up to the buyer to be compliant with and do maximum due diligent effort to get the loan approved. They should always keep you and the seller informed about the process and the status of their loan application. As soon as they receive notice that the loan has been approved, they need to notify the seller immediately. Also, if they receive notice that the loan has been denied, they also need to send notice to the seller immediately. If the time comes and the expiration of the loan approval period is slowly occurring within the next day or two, the buyer needs to make a decision. Either they can waive the loan approval process and continue without the loan, they can ask for an extension, or they can terminate the contract. But if they do not do anything, the loan approval shall be deemed waived, in which event this contract will continue as if the loan approval has been obtained. However, the seller may elect to terminate this contract by delivering written notice to the buyer within 3 days after the expiration of the loan approval period. And obviously, if the contract is terminated, if the buyer defaulted, then the seller would receive the escrow deposits. If the buyer did not default, then the escrow deposit would go back to the buyer. There are other two options for financing: is assumption of an existing mortgage or a purchase money note and mortgage to seller, such as seller financing. These two would require an additional rider to be attached to the contract, and also would require you to seek legal counsel because the terms can get kind of complicated and lengthy, and they need to be very specific about the terms, the rates, the fees, etc. It needs to be all drafted up. So to avoid any future disputes. So it is highly advisable, almost required, that their additional legal counsel be seek to write up those drafts. Closing cost and fees. In this section, you will see all the costs that are to be paid by the seller and all the costs that are to be paid by the buyer. Title evidence and insurance. So over here, it will describe the details about the title evidence and insurance, when the buyer is expected to receive the title insurance and the commitment. Also, who will be paying for these charges. So if the seller is paying, usually the seller will designate the closing agent, and if the buyer is paying, vice versa, the buyer will usually pay for that. Also, there's another provision for Miami-Dade Bravo regional provision where the seller can furnish a copy of the previous owner policy and pay for a continuation or update of such title evidence, which is acceptable for the buyer's title insurance underwriter for a reissue of that coverage. And then the buyer may, at buyer's expense, have the property surveyed. If the seller does have a survey, then they shall furnish that survey to the buyer and to the closing agent within 5 days after the effective date. Special assessments. So the seller shall pay the full amount of any liens imposed by a public body. This does not include a homeowner association, public body, like government-wise, that are certified, confirmed, and ratified prior to closing, and the amount of the public body's most recent estimate for an improvement which was substantially complete as of the effective date, but has not resulted in a lien. The buyer will pay for any other assessments, such as special assessments that are a small tax that will be paid every year until it's finalized. Usually you will just select option A, where the seller shall pay installments due prior to closing and buyer shall pay installments due after closing. The next portion is disclosures, which are your standard disclosures for radon gas, flood, energy brochure, lead paint, etc., homeowner association, seller's disclosure. You can make note that the seller's disclosure is actually pre-printed on here, but you still would be advised to get the seller disclosure form where they would list any known disclosures that they would have to disclose. Property inspection right to cancel. So here is a main difference between the standard contract and the as-is contract. Over here you will note that the buyer will have a certain amount of days, so let's say I put 10 days here. The buyer will have 10 days after the effective date to inspect the property, and the buyer can cancel any time within this 10-day period for any reason or no reason at all. Unlike that standard contract, the seller is not obligated to make any repairs on the property. But since the buyer can cancel the contract, oftentimes there is negotiation. So if the buyer does find repairs that are needed, the buyer can negotiate this with the seller and they can come to an agreement of what the seller will repair and how they are going to repair that, or perhaps give a credit, whatever it may be, and you would write that as an addendum to this contract. For the walkthrough inspection, this just notes that the buyer can do a walkthrough the day before, usually before the closing, and the only purpose of the walkthrough is just to confirm that the property is being maintained as required by the as-is maintenance requirement, but has also met all other contractual obligations. So if there were any addendums that were put with this contract that stated that the seller had to perform specific duties, then those should have been met by this walkthrough. Seller assistance and cooperation in closing out of building permits. So if the buyer finds out that there are open building permits, then the seller needs to cooperate with the buyer and assist with the buyer in any way they can to help close out these permits. But in this will detail how the buyer should do that. But the seller will not be required to expend any money or pay for anything to close out these building permits. Nor are they required to close out these building permits. So I always recommend that code violations and permits, and even particularly doing your own lien search during this inspection period. That way you can address it during the inspection period and cancel if you need to, because even though you're doing the title search, which we'll get into later, the seller may not be required to cure all of those type of violations, and it can technically convey with the property. So it's a good time to do that during the inspection period and notify the seller if anything that needs to be resolved. Next, we'll just get into the escrow agent and the broker. It just gets into the duties and responsibilities of these people. And in cases of default, it lists here who will receive the escrow deposits. If there's any dispute, it will go into here how those disputes will be mediated. Title evidence restrictions. And so within the time period specified in paragraph 9C, the title commitment shall be delivered to the buyer, and it will list any exceptions that will be put on the title commitment and on there as well. Now, if there are any issues within these bullet points, then that would be considered as a title defect, and the seller would be obligated to cure those title defects as long as you let the seller aware of these title defects. But if there's any other violations, such as code violations or building permit issues, that might not necessarily make the title not marketable, and so it could technically convey with the property, which is why earlier I had stated that it's better to do your own search of those items during the inspection period. Now, after the buyer receives the title commitment, they will have 5 days to examine it, and if there's any title defects, they will let the seller aware of those defects and give the seller time frame to cure those defects. If the survey discloses encroachments on the real property, or that improvements located thereon encroach on setback lines, easements, or lands of others, or violate any restrictions, the buyer shall deliver written notice of such matters, together with a copy of the survey, to the seller within 5 days after the receipt of the survey, but no later than the closing. Liens. So the seller shall furnish to buyer at closing an affidavit attesting to the absence of any financing statements, claim of liens, or potential lieners that are known to the seller, and that there have been no improvements within the past 90 days. If there was any improvements within the past 90 days, they should get a closeout from those contractors stating that they are not going to be pursuing any liens. When it comes to this contract, calendar days are going to be used in computing time periods. Except for the time of acceptance and except for the effective date, any time period that ends on a Saturday, Sunday, or national legal holiday will automatically extend to 5 p.m. the next business day. So let's say the inspection period is to occur for 10 days after the effective date, and the 10th day actually ends on a Saturday. You technically have until Monday 5 p.m. for the inspection period. But should you wait that long? Obviously no, try to get it done by Friday, but when it comes to technicalities, yes, you do have until Monday. Let's see here, next we just have some information about the closing location, closing documents. escrow closing procedure, prorations, and finally we will have the additional writers that can be attached. So if there's any other writers that need to be attached, you would check it off here. Any additional terms, you would check it off here. Have both the buyer and seller sign here. Also, each page needs to be initialed by both the buyer and seller. Also here you would notate the names of the cooperating brokers and the listing broker. So I'll just put here you're not going to put, I know some people put percentage of commissions that they are supposed to receive, but technically you're not supposed to put that here. You can attach a copy of the MLS to the contract, so just so that it's available for everybody to see how the commission is supposed to be dispersed, or get a copy of the listing agreement, which would be preferable. And after that is completed, you can email this for e-signatures, or manually sign, have it manually signed and upload this to your portal so that it can be reviewed.